term for this, the theme for this this conference is Peace, Justice and Accountability. And that is because we wanted to put the emphasis precisely on the question of accountability. So accountability, as you are all aware, is a very open-ended concept. At its core, it refers to the process of being called to account to some authority for one's actions. This definition implies that accountability is a relational concept between an actor and a forum in which the actor has an obligation to explain and to justify their conduct. The forum can pose questions and pose judgment, and the actor may face consequences. This is the definition that Bovens came up with, and I think is the most authoritative in the field. There are, of course, various ways in which to conceptualize this idea of accountability. What does justifying conduct mean? What are the consequences? And this is precisely what we're going to discuss today. There are different conceptions of accountability, and we are going to talk on the one hand on transitional justice, about transitional justice, where the focus is primarily on giving account. There may be consequences, but maybe not in the sense of actual sanctions. And we are going to compare that with criminal accountability, and where the focus is very much precisely on the question of the consequences and the sanctions. So, without further ado, I would like to introduce you to our four distinguished speakers. One of them is online. And Kevin, can you hear me? Kevin, I hope so.
Yes, I can hear you. Thanks.
Perfect. Good morning. So we have three speakers here in person, and we have one speaker online. So let's start with the order of the speakers. First of all, I would like to introduce you to Munini Mutuku, who is a member of the Environmental Peacebuilding Association, currently interim chair of the Transitional Justice Interest Group. She works at the National Cohesion and Integration Commission in Kenya. She's a fellow of the Pan-African Reconciliation Network at the Institute for Justice and Reconciliation South Africa, and a fellow of the Historical Dialogue and Accountability Program at Columbia University in New York. Her areas of work have focused on communities and natural resource-based conflicts, mediation and reconciliation, dialogues, diversity and social cohesion, women and youth in peace and security, minority and indigenous people's rights, economic and social cultural rights, amongst other thematic areas. She is a court mediator with the Kenya judiciary. Then let me move to Marcos Orellana. Professor Marcos Orellana is the current UN Special Rapporteur on Toxics and Human Rights. He has also served as a legal advisor for United Nations agencies, governments, and NGOs, including on waste and chemical issues at the Basel and Minamata Conventions, the UN Environment Assembly, and the Human Rights Council. Professor Orellana has extensive experience working with civil society around the world on issues concerning global environmental justice. He was the inaugural director of the Environment and Human Rights Division at Human Rights Watch, and previously he directed the trade and the human rights programs at the Center for International Environmental Law, and he co-chaired the UN Environment Program Civil Society Forum. Professor Orellana also teaches at the American University Washington College of Law. Then we have online Kevin John Heller. Professor Kevin John Heller serves as special advisor of the Prosecutor of the International Criminal Court on war crimes. In this capacity, he is developing the Office of the Prosecutor's policy on environmental crimes. He is also professor of international law and security at the University of Copenhagen Center for Military Studies and distinguished visiting professor of law at Universidad Torquato di Tella in Buenos Aires. Professor Heller is a member of the advisory board of the Bar Human Rights Committee of England and Wales and an academic member of Doughty Street Chambers in London. He has been involved in the International Criminal Court's negotiations over the crime of aggression, worked as Human Rights Watch's external legal advisor on the trial of Saddam Hussein, and served for 3 years as one of Karachi's formerly appointed legal associates at the International Criminal Tribunal for the former Yugoslavia. Last but not least, Maksym Popov. Maksym Popov is the advisor to the Prosecutor General of Ukraine. He is leading the direction of prosecuting ecocide, which is a crime in domestic law in Ukraine, and environmental war crimes resulting from the Russian aggression against Ukraine. Before he became advisor to the Prosecutor General, Mr. Popov worked as an environmental lawyer and a human rights defender. His work focused on protecting the natural environment through the rule of law, principle, and litigation, law enforcement in conservation and protected areas, promoting citizens and NGOs' rights to access information and justice in environmental matters, and legal aid to the human rights defenders of the human rights to clean and healthy and a sustainable environment. So a warm welcome to all panelists. Before I give the floor to Ms. Mutuku, two household matters. The first is that the program states that this session ends at 10:15 and then the coffee break starts at 10:30. So you might have guessed that this is not correct. The coffee break starts at 10:30, so this session ends at 10:30. And the second household matter is the organization of this session. So each of the presenters has 8 minutes for a presentation, after which we will open the floor for questions. So without further ado, Ms. Mutuku, the floor is yours.
Thank you very much, Daniëlla. And we're going to involve and the with the area for conservation and safety to imagine and just to talk about the judicial mechanism, but also then often raising the conflicts and now we will for but you cannot deny it. For conflict live
because the only microphone that's working is the one on the chat. We hear it in the room, you know.
So should I start again? Okay. Is that better?
Yeah.
Okay. So thank you so much for joining us in this session. My presentation today will focus on the work I and others have done in the nexus of transitional justice and environment, also to provoke thought and to elicit a discussion, not so much to give answers to the crises that we face as a globe. And transitional justice, we talk about the various mechanisms and formal and informal policy measures that societies adopt in order to overcome past violations and to build. Justice, we also talk about judicial mechanisms and non-judicial mechanisms that ensure that accountability, amongst other aspects, are undertaken. Now, transitional justice often operates in post-conflict societies and communities. And I was saying that some questions have been raised about how post-conflict is post-conflict and who decides that this is post-conflict. That is a discussion for another day. But we cannot undermine the fact that communities and societies live in ecosystems. Humans live in nature and we cannot separate the two. So in conflict and in war, humans suffer, and so does the environment and the ecosystems because the two are fragile. So for instance, we're talking about forest and woodland ecosystems that host forest communities. Forest communities face degradation, deforestation, and they also face illegal, unregulated logging. We're talking about wetland and aquatic ecosystems. These ecosystems hold coastal communities. For instance, coastal communities are dealing with the dumping of toxic waste. A case in example is Somalia, where we have had cases of toxic dumping along the coast of Somalia, amongst other countries. We're also talking about wetland communities or marsh communities. If you remember the marsh Arabs, the Iraq war, where the marshes were drained, destroying the cultural practices of this community, but also destroying the habitat of nesting sites for migratory waterbirds. That means the ecosystem is destroyed as much as the people are affected. We're talking about fisher communities who have to deal with polluted, poisoned waters, who have to deal with dead bodies, unfortunately, in river and water systems, amongst other destructions within this ecosystem. We're also talking about grasslands and shrub and ecosystems, or even arid and semi-arid ecosystems. For instance, these post-pastoralist communities who had to deal with the landmines and unexploded ordinances of war, the destruction of their livestock, the destructions of the landscapes. We are talking about agro-ecosystems, these post-agricultural communities who have to deal with landmines again and the unexploded ordinances of war, the destruction of crops in conflict and in war, the insecurities and also degraded landscapes. We are also talking about the transboundary ecosystems that host cross-border communities and cross-border resources. We are talking about forests, we're talking about water and rivers, and the challenges of accessing these resources and using these resources. Just to give some examples of how ecosystems host communities and the two coexist. Remember, landscapes and resources are not only physical. In post-conflict societies, these carry with them memories. For instance, there are places of torture and places of death. For instance, the Kagera River, or the Akagera River, if you like, in Rwanda, the riverbank was used as a place of torture and killing. And this river carried a lot of dead bodies. And that brings with it trauma to the society that is using this resource or that is living around this resource. Landscapes and ecosystems also fall with we tie our history. And we also have a sense of identity with this ecosystem. And also the spiritual aspect of it, where we have our cultural practices, our thoughts and our beliefs created around the environment of it. Unfortunately, there has been a long time assumption that post-conflict communities are unstable environments. And why do I say this? Because transitional justice for a long time has not looked at the ecology and the environmental aspects in post-conflict society. And so transitional justice largely has dealt with the human being and the injury to the human body, the political issues, the institutional issues, forgetting that there's an ecological issue that needs to be addressed. Transitional justice and accountability platforms again has often had that gap. So the question you may be asking is, so how does transitional justice then look at environment? Allow me to mention that transitional justice has 5 pillars, if you like, and you're talking about the truth-telling pillar, the justice pillar, the reparations pillar, the guarantee of non-recurrence pillar, and the memorialization pillar. When we talk about transition, what are we talking about? Transition from what to what in our space of environment? Transition from delinking the human from the environment. Transition from man is the master and nature is the subject. That attitude and that approach to how we approach nature. The transition from commodification to coexistence with nature. And the transition from one victim, who is the human being, to acknowledging that the environment is also a victim in transitional justice that requires attention. But we're seeing a lot of increasing acknowledgement in other areas. And in 2022, we have seen 24 countries have the rights of nature. At least by 2023, 11 countries have ecocide laws. In 2022, we had the United Nations Biodiversity Conference recognizing the rights of nature. We have community action. In 2023, we had a referendum in Ecuador, 59% of them voting against some mining, oil mining that was destroying the biodiversity. But let me say something. This does not make anything simple. If anything, it highlights the complexity of this field of transitional justice in this ecology space. How are they implemented is one question. How about the connectivity of natural ecosystems? How about acknowledging the tensions between development and environmental protection? Who pays for reparations? Who is in charge and who is accountable and who should be held accountable? So when we talk about this, what are we talking about? We are talking about post-conflict environmental impact assessment. And this is not the environmental impact assessment we do for projects. This is a different post-conflict environmental impact assessment approach. We're talking about truth-telling through environmental observations, post-conflict participatory ecosystem mappings by communities, acknowledging the risks that go with some of these methodologies, and also acknowledging that if the environment is a victim, then we need victim impact statement before the Truth, Justice, and Reconciliation Commissions, which collect these impact statements, and also green hearings. Can we have a hearing about the environment? When we talk about justice, we're talking about ecological justice, environmental remediation. A case in point is the Niger Delta UNEP remediation project that has been going on in the region. We're talking about restoration and rehabilitation. And more importantly, we're also talking about cognitive justice, where indigenous ecological knowledge and science is incorporated in this transitional justice mechanism. So reparations, repairing, what are we repairing? We're talking about fixing damaged ecosystems, repairing the relationship between the people and their ecosystems, also the institutions and their approach towards the environment and natural resources, and also repairing the education system. What perception does the education system give us towards the environment and the ecosystems within which we live? And how about guarantee of non-recurrence? Within this pillar, we talk about institutional reforms largely. And the question is, how do they address environment, integrated natural resource management, ecocentric approaches, anthropocentric approaches, even the education? How does it address this? And even in institutional reforms, the judicial systems, how do they address ecological and environmental damage? So in a snapshot, we are saying that the instruments of accountability, transitional justice being one of them, can no longer ignore the ecological concerns of conflict communities. Thank you.
Thank you so much, Ms. Mutuku, also for this powerful account of the connections between humans and nature, and the fact that transitional justice processes have so far largely ignored these connections. I think we will see a similar picture when we talk about international criminal law, where the idea is the same, that nature has very much been ignored as part of these accountability processes. And I think your account shows why it is so important to actually address that. Professor Orellana, may I give the floor to you, please?
Thank you very much, Daniëlla, for your introduction. Thank you also to the organizers for their kind invitation to join you here today. My name is Orellana. I am acting as the United Nations Special Rapporteur on Toxics and Human Rights. This is a special procedure of the United Nations Human Rights Council. It's been described as the eyes and ears of the Council. It's a monitoring and reporting mandate. In these few minutes that we have together, I thought I'd share some remarks about accountability in the context of nuclear weapons detonations, and specifically the legacy of contamination resulting from these testings. Nuclear legacies exist in various places of the world. Think about Algeria and French detonations there, records of where radioactive wastes are still kept secret to this date. In Kazakhstan, one of the most difficult waste issues pertains to the contamination of Soviet detonations at the time. I had the opportunity to conduct a country visit to Australia, where descendants of indigenous peoples there spoke about the black mist that left their ancestors blind. But I did want to concentrate a few minutes on the detonations conducted by the United States of America in the Republic of the Marshall Islands. And this is because there is an angle of responsibility involving the international community as a whole. In 1947, the UN Security Council designated the Republic of the Marshall Islands as a trust territory and designated the United States as the administering authority. Between 1946 and 1958, the United States detonated 67 nuclear bombs in the Republic of the Marshall Islands. One of my predecessors in the mandate conducted an official country visit to the Republic of the Marshall Islands, and he found a legacy of near irreversible contamination and distrust. He found impairments of the rights to life, right to health, fatalities, health complications, including hair loss, cancers, growth retardation in children. He found gendered impacts as in reproductive problems, stillbirths, congenital birth defects, miscarriages. He found issues concerning the right of access to information and medical records withheld from the victims. And he also found issues of displacement, self-determination issues, right to food, cultural rights. This leads me to two observations in regards to accountability and justice. The first one on compensation. The compact of free association between the United States and the Republic of the Marshall Islands of 1986 established a nuclear claims fund and a nuclear claims tribunal. It established $150 million US dollars for this fund. What's interesting, among other things, in this arrangement is that the United States accepts responsibility. It's not an ex gratia payment. It accepts responsibility for compensation for loss or damage resulting from the US nuclear testing program. However, the funds have proven to be insufficient, and a petition by the Marshallese to the United States Congress dating from the year 2000 remains pending, so it hasn't been acted on. A second observation concerns transitional justice, building on the previous presentation. In October of 2022, Human Rights Council adopted Resolution 51/35 on technical assistance and capacity building to address the human rights implications of the nuclear legacy in the Marshall Islands. Now, this resolution has various preambular and operative paragraphs to pick up on two. One on capacity building. Recognition that a small island does not have the capacity, material, physical, to deal with the wastes from the nuclear tests and to remove those wastes from its territory. And secondly, it speaks about elements, explicitly, of elements of transitional justice in capacity building. And in this regard, by preserving the memory of injustices, there can be healing in present and future generations. By engaging in truth-telling and documentation, there can be a historical record. And by remembering past human rights violations, there can be a tribute to the victims. Now, with this factual, historical, and present situation in mind, I would wish to problematize it or this around it on two legal issues pertaining to state responsibility for internationally wrongful acts. I will announce them because of time. I don't think I'll have a chance to elaborate. The first one, could the detonations be considered internationally wrongful acts? And the second one, is the radioactive pollution resulting from nuclear weapons testing a continuing act? So on the first issue, could the detonations be considered internationally wrongful? Various arguments. One line of argumentation is that detonations were not wrongful at the time because there was no specific rule establishing an obligation not to conduct nuclear weapons testing. And any implication or conclusion that these testings were wrongful would be an exercise in retroactive application of newly emerged standards. At the same time, there's other lines of argumentation that nuclear weapons testing have a very close connection with colonialism or a colonial mindset, that self-determination as a principle and norm already existed by virtue of the UN Charter, and that in this regard, the Human Rights Bill of Rights, so this is the Universal Declaration of Human Rights and the two international covenants on civil, political, economic, social, cultural rights elaborate and codify on the principle and right of self-determination. So where does this take us? In the analysis of this question, what's been also interesting is the International Court of Justice articulation of what some have called the Chagos principle. Short. In 2019, the International Court of Justice rendered an advisory opinion on legal consequences of the separation of the Chagos archipelago from Mauritius in 1965. And I will read paragraph 143, which says the court may also rely on legal instruments which post-date the period in question when those instruments confirm or interpret pre-existing rules or principles. Which is the pre-existing rule or principle here? The principle of self-determination. And so there's a first layer, the International Covenant on Civil and Political Rights interpreting the principle of self-determination in connection also with the rights to life and personal integrity. There's a second layer, for example, in the UN Declaration on the Rights of Indigenous Peoples, interpreting the International Covenant on Civil and Political Rights as has been confirmed by the Human Rights Committee, which is a body that oversees implementation compliance with the ICCPR in the Portillo Cáceres case involving Paraguay. So just as an aside, and in the last minute, I did have an opportunity to visit Paraguay and speak to Ms. Portillo. This is a case involving pesticide spraying over fields right next to her house. Her husband died as a result of exposure, among other people in her family. So the question is, how far can the Chagos principle be taken in this connection? So I won't have time to get into the second issue of whether radioactive pollution resulting from nuclear weapons testing is a continuing act. Perhaps we can deal with that in the question. So to conclude, legacy issues impose significant conceptual and other challenges on human rights, law and policy, especially in regards to peace, justice, and security. The detonations of nuclear weapons still reverberate today. Thank you for your attention.
Thank you so much, Professor Orellana, and also for bringing in the state responsibility framework. Because when we look at this question of accountability, I introduced it as a relational concept between an actor who is giving account or who is held to account and a forum that is well, basically providing or in any case holding the actor to account. And I think there are important questions here also when we compare international criminal justice, which is very much focused on the individual with the state responsibility framework. Transitional justice is in that sense a bit more mixed, where both the state and individuals can be held to account. So that's an important question. So who are we holding to account and for what? And also, who are actually the victims? Because in your talk, you referred to the intergenerational effects. So the legacies that transcend generations. You were talking about birth defects. And this is, I think, also an important question when we think about the justice aspect and the accountability aspect. To what extent are these future generations that are impacted also included in these processes? So maybe that's also something to for the discussion later. Now I would like to give the floor to Kevin John Heller. So Professor Heller, please, the floor is yours.
Thank you, Professor Dam. And thank you to all the organizers for inviting me. I'm very, very sorry that I can't be there in person, but I am really happy that I can at least address you via the magic of the internet. So in mid-February of this year, the prosecutor of the International Criminal Court, Karim Khan, publicly announced in Paris that his office would be developing a policy concerning environmental crimes. Damage to the environment poses an existential threat to all life on the planet, he said. For that reason, I am firmly committed to ensuring that my office systematically addresses environmental crimes in all stages of its work, from preliminary examinations to prosecutions. This latest policy initiative is another commitment to this necessary objective. So for the past year, I've been working with an attorney in the Office of the Prosecutor to develop the policy that the prosecutor himself mentioned in Paris. We began the process by asking the public for what we called blue sky comments. Comments not on a specific draft of the policy paper, but simply telling us what they would like to see in the policy itself. The call for comments was a great success. We received nearly 80 submissions from a diverse pool of states, including Ukraine, IGOs, NGOs, corporations, academics, and even individual activists. The comments came literally from all over the world, from Africa to Australasia, and we were particularly happy to receive a number of comments from youth groups and groups dedicated to Indigenous rights. We used the comments we received to write a draft of the policy paper. We hope to be able to release the draft to the public in the next couple of weeks for another round of public input. We will then produce a final draft of the policy paper and, with a little luck, release it by the end of the year. So let me now turn to the policy paper itself. I don't want to say too much because you will soon be able to read it for yourself. The paper is divided into 3 sections. The first explains the importance of the policy, the relationship between environmental damage and armed conflict, and the central role that environmental crimes have played and continue to play in situations the OTP is currently investigating, from Myanmar to Ukraine to Palestine. It also emphasizes the need for the OTP to take an intersectional approach to environmental crimes, recognizing that they, like environmental damage more generally, disproportionately affect vulnerable groups such as women, children, and members of Indigenous communities. The second section of the draft policy paper then explains precisely what kinds of environmental crimes are within the 4 corners of the Rome Statute. The section goes systematically through genocide, crimes against humanity, war crimes, and aggression, with a particular focus on crimes against humanity and war crimes. In terms of crimes against humanity, we emphasize extermination, deportation or forcible transfer, persecution, and other inhumane acts. And once again, the emphasis is on how these crimes can be committed against vulnerable individuals, particularly members of Indigenous communities, given their unique relationship to the natural environment. In terms of crimes, we focus on intentional attacks against civilian objects, noting, importantly, that the environment is, by default, a civilian object, the destruction and appropriation of property, and starvation. The third and final section of the paper discusses how the OTP will put the environmental crimes policy into action. Simply put, we intend to consider the environmental dimension of Rome Statute crimes in every phase of the office's work: preliminary examination, investigation, and prosecution. When we assess the gravity of crimes, we will take environmental damage, both to humans and to the non-human world, into account. When evidence permits, we will include charges that encompass environmental damage. And in all relevant cases, we will argue that environmental damage should be considered an aggravating factor at sentencing. We believe that the policy paper heeds the prosecutor's instruction to us to be as innovative as possible. And I think you see that innovation, or will see that innovation, in 2 basic ways. The first is the policy paper's thoroughgoing emphasis on complementarity and cooperation. The third section explains at great length how the OTP can promote national efforts to prosecute environmental crimes, even perhaps when those crimes do not fall within the court's jurisdiction. The second innovation is then the emphasis on corporate actors. We make clear that the OTP cannot prosecute corporations as legal persons, but we also emphasize that the office can and will use its powers to prosecute corporate officers who commit environmental crimes through the corporation. We also believe that the policy paper has great value because our sense is that people often underestimate how many different kinds of environmental damage can, in fact, be prosecuted under the Rome Statute. Now, that said, we cannot lose sight of the ICC's limitations concerning the prosecution of environmental crimes. And let me very briefly mention 3. First, and most importantly, the OTP's efforts can never exceed the jurisdictional, substantive, and procedural provisions of the Rome Statute. We specifically point out in the policy paper, for example, that the court has no jurisdiction, at least at the present, over the crime of ecocide. Second, it's very important to acknowledge that the Rome Statute is primarily anthropocentric, focusing on harms to humans, which means that the OTP will usually be limited to investigating environmental damage that has at least some adverse effect on individuals and groups. Beyond the ICC, we need an ecocentric approach to environmental protection, one that protects the rights of non-humans as well as humans. Third, and finally, it's also important to acknowledge the practical limitations of the ICC. We are perennially understaffed and underfinanced, and that means the OTP will never be able to prosecute anything more than a small handful of environmental crimes. For that reason, and this is what I will end with, the ICC needs to be seen as one important but small piece of the environmental justice puzzle. The ICC is often seen as the court of first resort when it is designed to be the court of last resort. International prosecutions of environmental crimes will always be necessary, particularly when states are complicit in environmental damage or the bad actor is a powerful multinational corporation. But environmental justice will never be more than an abstract ideal if states and civil society do not take the lead. We need states to adopt stronger environmental laws. We need states to prosecute environmental crimes domestically. And neither of those things will happen without the constant efforts of civil society. And that is perhaps the most important role the ICC can play, catalyzing and supporting national efforts at environmental justice. The OTP can develop and share evidence with states. We can help states communicate with each other. We can bring international attention to the concerns of activists. We can, in short, be the hub that all the environmental folks connect to. That, in any case, is our goal, and we believe that the new policy will be a first step toward achieving it. Thank you.
Thank you, Professor Heller, for explaining this very important, I would even say revolutionary development in the ICC. Critics might, of course, say it's too little, the ICC can't do enough, but I'm more of an optimist because I think simply because the ICC is now giving attention to the environment, even if it's only in relation to the harm to humans, is of an incredibly important symbolic function. It is recognizing that environmental harm is important and that it is something that is criminally punishable. And I think another important point that you made is that the ICC can only do so much. But that it's very important that the ICC can catalyze domestic action. And that also brings me to the last presentation of today by Maksym Popov, because it is precisely this domestic action that he will be talking about. But before Mr. Popov will start his presentation, let me, and then I need to do a screen share. Oh yeah, of course. No, I do. No, sorry. Share. No, that's the wrong one. Apologies. Okay, wait. Give me 1 minute. Stop sharing. Where is it? Okay, maybe. Okay, then try to pause. No. Okay. I'm having a bit of an issue here. Wait. No, it's not good. No, it's not good. I'm very sorry, online participants and Kevin, but I think I need to. Okay, I'm going to. Okay, I've lost the video. We'll see. Oh, yeah, yeah. Okay, yeah. Okay, so we're going to show a video, but it will not be visible online, I'm afraid.
Before Russian aggression, you think of the large problem of the damage. This must change. Russia uses destruction. The air has been polluted by over 2 million tons of We must stand united. It's the first thing the international
So a powerful message. Okay, and now this I can share. Okay.
Hello, dear participants. It's a great honor for me to stand today here and share the information about the efforts that Ukraine is trying to do towards ensuring accountability for the wartime environmental damage. I'm representing here Office of the Prosecutor General, and since 2022, our office prioritized this area and decided to allocate the resources to try to find a way to hold individually criminally responsible representatives of the Russian Federation for the wartime environmental damage. Here is the part of the environmental impact of armed conflict resolution of the Parliamentary Assembly of the Council of Europe, which clearly states that each and any war is equally destructive, not only for the human beings, for the property, but also for the environment. Environmental damage resulting from armed conflict can be multifaceted, severe, long-lasting, and mostly irreversible. It not only harms natural habitats and ecosystems, but can also affect human health well beyond the conflict area and long after the conflict is over. The human rights to life and to a healthy environment are thus undermined. Here you can see many angles of the damage to the natural environment, including the angle of the violation of the human rights, including the new emerged right to healthy, sustainable environment. Here are some facts. Unfortunately, in terms of the timing, I couldn't allocate all the information in terms of the environmental damage and environmental consequences of this war. Just for your awareness, as up to now, 25% of the territory of Ukraine is contaminated with the landmines. Under the threat of destruction, 160 emerald network sites, it's almost 2,090,000 hectares, 70 Ramsar sites under the threat of destruction. And it was also recognized by the resolution of the States Party, but to the Ramsar Convention. Up to now, 10 national parks are under the occupation, 8 national reserves and 2 biosphere reserves. Here are some facts. Probably you may know, you may hear that on the 6th of June 2023, Russians military troops blown up the Kakhovka Dam, which caused long-term severe and widespread environmental consequences, actually environmental disaster. 35 people died due to flooding. 80 settlements were flooded. The area of flooding is 610 square kilometers. At the very same day, we opened the investigation under the 2 articles. One is the war crime, and the second one is ecocide. At the very same day, Prosecutor General informed the Office of the Prosecutor of the ICC about this incident. And in a few days after that, there was a joint visit to the Kherson region to show the Office of the Prosecutor of the ICC representatives the real consequences. From the very beginning, from the full-scale invasion in 2022, we were moved by the motto created by ourselves, that environment should no longer be the silent victim of war. At that time, when I started exploring this area, I actually found a lot of materials and information where usually environment was considered as a silent victim of war, and we decided to change it. As up to now, we opened investigations in 207 cases on the war crimes that resulted to a damage to the natural environment. 14 among them is the cases under legal qualification ecocide. In order to make this effort successful within the office, we established the structure. We have the specialized environmental prosecutor's office, SIPO. Within this department, we created the special unit of the prosecutors who are dealing specifically and exclusively with the environmental war crimes and ecocide. We established the coordination with other departments responsible for the prosecuting of other war crimes. Just for your information, as up to today, we have registered 130,000 incidents of the war crimes. So we have the war crimes department who is largely responsible for the prosecuting of other war crimes, and the SIPO is responsible for the prosecuting of environmental war crimes. We are closely cooperating with the state agencies, including State Environmental Inspectorate, who is responsible for the documenting of all environmental damage resulted by the aggressive war of Russia Federation against Ukraine. Apart from that, the Ukraine as a state also prioritized the protection of the environment through the criminal law, and not only. The Office of the President in 2023 established high-level international working group on environmental consequences of war, co-chaired by Margot Wallström. You may saw her yesterday on the gala evening, and the head of the Office of the President, Andriy Yermak. And the result of the work of this group is the document, which is called Environmental Compact, and it was presented on the 9th of February 2024 to the President of Ukraine. This document actually contains 50 recommendations in 3 important fields: documenting of environmental damage and assessment, accountability for the wartime environmental damage, and green recovery. These recommendations addressed to Ukraine and the international community, and we are already on the way of developing implementation plan to move forward. Also, we are not alone in this fight. Our efforts are supported by a lot of partners. You can see here, we named few of them: the Atrocity Crimes Advisory Group for Ukraine, which operates through 5 implemented entities, NGOs like Climate Council, Justice Rapid Response, ULCLA, Law Promise Institute Europe, Project Expedited Justice, and many others. What is equally important, we created within the International Council of Experts is the platform for cooperating with the civil society organizations, the thematic cluster, and we gathered 25 non-governmental organizations who are helping us in this effort. one of the greatest results, which I can name, is the common report which was produced by the Project Expedited Justice and Truth Hounds organization that dedicates to the Kakhovka Dam case. They explored the consequences, environmental consequences of this war crime, and clearly established the person who is responsible for that, and clearly establishes the legal qualification of this war crime. As for the applicable legal framework, within the National Domestic Criminal Code, we have two articles. One is the 438, which prescribes responsibility for the war crimes. And the second one is 441, is crime of ecocide, which is criminalized in 2001 in Ukraine. Here is, you can see the definition as it is now in our criminal code. So under ecocide, it is meant mass destruction of flora and fauna, poisoning of air or water resources, and also any other actions that may cause an environmental disaster. At the very beginning of this work, it was a huge challenging question, how to implement, how to apply provisions of law of the armed conflict in order to prosecute and build these cases. And result of this work is here. So we have right now the guide to identifying and framing environmental war crimes in Ukraine, prepared by the Climate Council and reviewed and agreed upon by the SEPO and other organizations and international lawyers. I would say that this guide is clearly useful not only for Ukraine, but for any other state that did not ratify yet the Rome Statute. And here in this guide, you can find all possible options to prosecute wartime environmental damage under IHL provisions. Also, we already developed the protocol on best standards and practices in the area of child rights standards and child-sensitive approach when collecting evidence from and engaging investigation in judicial process with children affected by environmental crimes, prepared by Justice Rapid Response and reviewed by SEPO. In Kakhovka Dam case, we decided to try to find and establish the link between the destruction of the Kakhovka reservoir and the influence on the public health. So we collected 100 samples of hair of 100 children in Zaporizhia region, and we are going to, we have sent these samples to the lab to evaluate the heavy metals, just to understand if there are any impact of the Kakhovka Dam destruction on the public health. As for now, we have some results of our work. First of all, it was the first notice of suspicion that issued to a Russian colonel general and 4 of his subordinates involved in the shelling of the neutron source research facility and the storage of nuclear materials located on the territory of the Kharkiv Institute of Physics and Technology. This is the first suspicion notice for the crime of ecocide, along with the crime of aggression and the war crime. Also, we issued the notice of suspicion to a Russian colonel general who coordinated the destruction of the Kakhovka Dam. This is the third major investigation result, which indicate that the hydropower plant was mined by Russian occupation forces and destroyed as a result of their actions. The forensic examination in terms of establishing the environmental consequences is still ongoing. I hope that this year we will finalize it and will come up with the notice of suspicion on ecocide as well. Here are the number of challenges that we faced from the very beginning. I already mentioned that there is lack of case law related to environmental war crimes in Ukraine before international courts and tribunals, as well as in third states practice. Lack of universal definition of the crime of ecocide on an international level. Of course, we are really grateful to the independent panel of experts who actually created the definition of ecocide. We are thinking right now on the amendments of our domestic criminal code, but the challenge is that if we will amend it right now and use this definition, our investigators and prosecutors will face challenging in terms of retroactivity of the criminal norms, and it will be challenging for them to prosecute the facts that what was before under the provisions we have. and the facts that will be in future or could be in future under the new definition. That is why we realize for ourselves that we need to amend this article, but it's not the proper time right now. There is my personal assumption. I believe that Ukrainian efforts towards the ensuring accountability for the wartime environmental damage has already become the catalyst for the advocacy campaign on the recognition of ecocide as a fifth international crime. We are cooperating closely with the Stop Ecocide Foundation, exchanging information and providing them the possibility to raise the awareness of international community on the environmental consequences of war and the necessity to have clear legal pathway how to proceed when it may happen in any country. We tend to set a precedent of individual criminal responsibility, as I already said, and I assume that our work and all these guidelines, our practice could become a legacy and could become a guide for international community and for other countries who may possibly face with the same challenge as we faced, aggressive war of Russian Federation, as well as the methodics of evaluation and documenting of environmental harm resulted by war. And here is the part of the report of Antonio Gutierrez, UN Secretary General, dated 4th of May 2024. It clearly recognizes the efforts of Ukraine to prosecute war crimes and also investigate the destruction of Kakhovka Dam and other environmental damage resulting from the conflict. And as a result, Antonio Gutierrez is calling to advance accountability for environmental damage in armed conflicts that requires the international and national courts consider more systematically existing international crimes committed by means of or that result in environmental damage. As a result, in my opinion, I could clearly state that environment is not a silent victim of war anymore. Thank you for your attention.
Thank you very much, Mr. Popov, for sharing the experience currently in Ukraine with the investigation of crimes, including the crime of ecocide. And I think Ukraine sets an important precedent also because it is, to my knowledge, the first country that actually actively monitors environmental harm during the conflict for the purpose of holding the perpetrators to account afterwards. So in the domestic legislation of Ukraine, ecocide is a crime. And as Professor Heller already set out, this is not yet the case at the international level, at the ICC. There are also developments towards formulating a crime of ecocide that might be included in the Rome Statute. So I'm very happy that one of the drafters of an important definition in this respect is in the audience, Professor Christina Voigt. Of course, this is all very much a long process, but I think it's an important process and in any case, an important discussion. And as we know, things move slowly, but I think especially with this domestic experience and also more recognition for the environmental harm that occurs during conflicts, I'm fairly confident that in time this will evolve. But for now, we have to deal with the limited means that we have. So that's also a conclusion. Let me open the floor to questions. Do we have two people who can help with the mics? Maybe I ask you to, yeah.